Okay, I'd like to go on to chapter 13 now, which deals with something called breach of contract. As we pointed out when we began this section on contracts, contracts involve promises. They have promises in them where one party, for example, agrees to pay something for something, or the other party agrees to deliver something. So we trade promises. A bilateral contract is the trading of promises. If the parties keep their promise, the contract is discharged and everybody's happy. I get paid, you get whatever it is you bought from me. But what happens when one party fails to keep his or her promise? That allows the other party, or that's called, first of all, a breach of the contract or breach of the promise, and allows the injured party, that is the person suffering from the failed promise, or the breach of the promise, or the broken promise, call it breach or broken promise. That allows the injured party to claim damages, something called damages, against the party who breached the contract. Damages usually involves the payment of money, where they can sue the person who didn't keep their promise and get some money from them. We'll talk about what that means in a little bit, in a bit as we go through this. This is all explained in chapter 13 at page 275 under implications of breach. And what you have to understand is that there's sort of minor breaches of the contract and major breaches, or small promises that are broken as opposed to big promises that are broken. If you have big promises that are broken, then you get more damages, and you may even be allowed to withdraw from the contract yourself, that is the injured party, without having to perform your part of the bargain. This is a very complex area of law. I don't intend to have you understand 100% of it at all, but I want to just take you through it a bit and introduce you to these concepts here. In page 275, under implications of breach, let's read that together. A breach of any term in a contract entitles the non-breaching party, that is what I call the innocent party, if you like, to claim damages. However, serious damages may also discharge a contract and release the non-breaching party from any further performance of his or her contractual obligations. To discharge a contract, the breach must undermine the whole contract or a substantial part of the contract. Only then is the option to discharge the contract available. The purpose of the contract must be defeated so as the performance of the non-breaching party is rendered pointless. So what does that mean? Let me give you an example that I may refer to many times. Let's say I own a grocery store here in Sault Ste. Marie, and I'm buying vegetables from you, and you live in Toronto, and you have a store in Toronto, a wholesale store. And we enter in a contract where I agree to buy a truckload of tomatoes from you. You send a truckload to my business. I open up the truckload, and it's not tomatoes at all, it's grapefruit. That's a broken promise. You promised to deliver tomatoes. It's also a major promise. It's a serious promise, a serious breach of the promise. I didn't get any tomatoes at all. I got something else called grapefruit. That allows me then to discharge the contract by saying this: look, I don't want to take delivery of this grapefruit, turn around the truck, and take it back to Toronto, and I'm not paying for it. That's different than if I entered into a contract with you that said, I want Roma Italian tomatoes. And you send me tomatoes, but they're not Roma tomatoes, they're some other type of tomato. That's a broken promise too. I didn't get what you promised me. But it may not be a major breach of a promise. You still delivered me tomatoes. So I may have to take delivery of them and pay for them but also sue you for any damages that I may have occurred because they were not Roma tomatoes. So if I could show that I would have made more money by selling Roma tomatoes than these ones that you gave me, then I'm entitled to sue you for that difference. But I'm not entitled to discharge the contract and not pay for them and not take delivery. So let's go through here and try to understand this concept a little bit more. Breach does not discharge a contract automatically. Even when a breach is sufficient to discharge the contract, the non-breaching party must choose to treat the contract as discharged and communicate this. For example, again, to go back to my example, I ordered tomatoes from you. You send me grapefruit. I don't have to say I'm not paying for them and not taking delivery. I could take delivery of the grapefruit and pay for them and not discharge the contract at all and sue you for what I would have made if they would have been tomatoes. But I have the option there. If it's grapefruit and I ordered tomatoes, I can either say, turn around the truck, take the truck back, take the grapefruit back, or take delivery from them. I can discharge the contract, or I can complete the contract, pay for the grapefruit, and sue for damages for if I had any losses from the fact that they weren't tomatoes. Now, what if I make more money from the grapefruit than if they were tomatoes? Then I don't have something called a loss, and I don't have any damages because I made more money from the grapefruit than I did from the tomatoes. But let's look at this illustration 13.1 at the bottom of page 275, and I'd ask you to read that a number of times. Illustration 13.1, essential term. A agrees to sell 10,000 bags of potatoes to B with nutritional content printed on each bag in 28-point font, so on and so forth. By mistake, the information is printed in 20-point font. Now, there's a breach of the contract there. There's a promise that it would be a certain font, and it didn't come in a certain font. B may feel annoyed and believe that its merchandise display will not be as effective. B may sue A and collect damages for its loss, but it cannot reject the potatoes without committing a breach of contract that may make it also liable for damages. See, in that situation, there was a small promise broken. B still has to take delivery of potatoes. If he says, no, I don't want them, then he's committed a bigger breach of the contract than A has, and A may be able to sue him and say, you should have taken the potatoes. Now I've got them. I couldn't sell them. They went rotten. I'm suing you for the whole price, less whatever you would have made had the font been proper. So read that A part there on illustration 13.1 a number of times, and it'll make some sense to you. But on the other hand, on B, A agrees, at the B part of illustration 13.1, A agrees to sell 10,000 bags of potatoes to B and deliver them to B's warehouse on Wednesday in time for B to distribute them to a supermarket chain for a weekend special. A makes no delivery until late Friday. This may be a breach of an essential term of the contract, delivery on Wednesday. B may reject the potatoes and discharge the contract, that is saying not taking them at all, freeing itself from any obligations. In addition, it may sue for A for damages caused by failure to deliver on time. But B may decide it wants the potatoes and still accept them. In this event, the contract is not discharged. B is liable to pay for the price of the potatoes, subject to a deduction for damages caused by the failure to deliver on time. If B should accept the potatoes and then refuse to pay for them, A could sue B for the price, and B could counterclaim for his damages. So that's a difficult concept to understand, except for if you just put it in terms of major breach, minor breach. Both allow someone to sue for damages. What does damages mean? It means if you can show the court that you lost any money, if you lost any money because of the breach of the contract, the court will give you that money.